The tenancy law in Nigeria does not favor landlords. As a matter of fact, it is a weapon fashioned against landlord. Today, our topic for discourse is illegal eviction in Nigeria. Illegal eviction in Nigeria. First, let's start by defining some terms that we will come across in the course of this discourse. Who is a landlord? A landlord is a person who owns landed property and confers on the tenants rights of usage or rights of occupancy. The landlord retains what is called reversionary interest in the demised premises. Who is a tenant? A tenant is a person to whom a landlord grants right of usage or right of occupancy for a specific period of time. What do we mean by demised premises or rental property? This is the object of the lease or rent. This is the building or the land being rented or leased. I've used the term lease and I've used the term rent, and you would ask yourself, what's the difference? Rent is basically a tenancy for a period less than 3 years, while lease is a tenancy for a period between 3 years and 99 years. What do I mean by eviction? Eviction is the lawful method or the lawful process through which a landlord removes a tenant from the demised premises and recovers possession. On the contrary, illegal eviction is the unauthorized measures taken by landlords to recover possession of the demised premises, sidestepping legal procedures. Some of these measures taken by landlords in this regard include forcefully ejecting the tenant from the premises, locking up the property so that the tenant will not gain access, confiscating the tenant's properties to recover unpaid rents, damaging the property to make it uncomfortable or even inhabitable for the tenant, cutting off water or power supply to the tenant's apartment, employing the services of officers from the armed forces or even hoodlums to arrest and harass the tenants in question. This very act is both unlawful and criminal, as matters relating to eviction is under civil jurisdiction. Since it has no element of crime, members of the armed forces have absolutely no business with such matters. As a matter of fact, the tenant can, depending on the circumstances of the case, pursue a claim against the landlord for damages, illegal eviction, and trespass. On what grounds can a tenant be evicted from a demised premises? According to the Lagos State Tenancy Law 2011, which is similar to most of the tenancy laws across the nation, even the federal law, a tenant can be evicted in any of the following circumstances. 1. Where the tenant is in arrears of rent. 2. Where the tenant interferes with the rights of other tenants or the landlord. 3. Where the tenant breaches a fundamental clause in the tenancy or lease agreement. 4. Where the tenant seriously damages the demised premises. Lack of maintenance. Where the tenant sublets the demised premises to a third party contrary to the lease agreement. 6. Where the tenant uses the property for unlawful or immoral purposes such as prostitution, harboring contraband goods, robbery, and the likes of them. 7. Where the landlord wants to personally or members of his family wants to personally make use of the demised premises. Where the landlord wants to perform structural repairs on the rental property. Okay? Having laid down the aforementioned background, let's look at the lawful processes through which a landlord can evict a tenant. 1. Issuance of late rent notice. This is usually the first step where the purpose of the eviction is non-payment of rent. The landlord can seek a claim for payment of unpaid rent and possession of the premises. It is important that the landlord issue the tenant a demand letter titled late rent notice, because this very document will be tendered as evidence in court to show that these tenants actually owe you. The second step to take is issuance of notice to quit. In local parlance, they call it quit notice. However, in legal parlance, we call it notice to quit. This entails giving the tenant a period of time, a period of notice to let him know that, Mr. Man, please, you have to leave my property. The length of time given by the landlord in this regard is dependent on the agreement that the parties had, the landlord and the tenant. So if, for instance, they agreed in the tenancy agreement, they have it signed that 1 week notice would be given for a yearly tenant, then that is what would preside. Okay, but where there is no such clause in the tenancy agreement, then the provision of the law would preside. What does the law say? The law says that for a yearly tenant, at least 6 months notice would be given. For a half-yearly tenant or quarterly tenant, at least 3 months notice would be given. For a monthly tenant, at least 1 month notice, and for a weekly tenant, at least 1 week notice. At the expiration of this notice, if the tenant still does not quit the apartment, then the landlord will proceed to the third step. Now, let me mention some things. This notice to quit does not mean that if, for instance, a yearly tenant, this does not mean that after the 1 year that the tenant paid for had expired, then the landlord will now give another 6 months. No. As the 1 year that was paid for subsists, in the 6th month, then the landlord can issue the tenant this 6 months notice to quit. That's in the middle of the year. So he has 6 months to the expiration of what he paid to pack out. Hope this is understood, right? And secondly, another thing you should note is that this very notice to quit does not apply to lease agreement. It only applies to rent agreement, because for lease agreement, the landlord has to wait till the lease term had expired. So let's say it's a 10 years lease. The landlord must wait, the 10 years expires. Then the landlord will issue what is called 7 days owner's intention to recover possession. All right, so that's the third step. So in terms of rent, after the quit notice period had expired, the landlord will issue 7 days owner's intention to recover possession. After the expiration of these 7 days, and the tenant still does not pay the rent and does not vacate the premises, then the landlord will proceed to the fourth step, which is commencement of action in court. Now, this would require the normal court processes where evidences will be tendered, witnesses will be called, and all that. Now, at the end of the day, when judgment has been given, depending on the claims or orders sought by the landlord, but on average, under normal circumstances, the court would order that the tenant vacates the premises either immediately or on a specific date. The cost of litigation, every dime that the landlord paid or spent, both the legal fee, everything, every dime the landlord spent on that suit will be reimbursed to him by the tenant. The period of time that matter spent in court, 6 months, 3 months, 8 months, however the case may be, the tenant would pay the rent period of that time, as long as the tenant stayed in the demise premises throughout the court time. The tenant must pay for that time. All right. Other damages that the court may deem necessary would also be paid by the tenant. Okay. Now, where it is evident that the tenant does not have the financial capacity to offset this debt, to pay up this debt, then any or all his properties will be confiscated by the court to the extent of the debt he owes. All right. Hope this is understood. In the beginning of this video, I mentioned that the tenancy law in Nigeria does not favor landlords. As a matter of fact, it is a weapon fashioned against landlord. this is a statement that a lot of landlords made to me when I went for a street interview. If you check my previous post, you will see it. Please go and watch it. It's very interesting to watch. All right. So this is the belief of many, but on the contrary, that is not the case. The reason why the law gives ample time to the tenant is so that he would have enough time to make alternative provision for his accommodation. Now imagine a tenant being evicted without prior notice. His property would risk being stolen and the rest of them. If it's a lady, she might be raped. There will be a lot of human rights violation. Okay, so this is the reason why the law considers them and make provisions, statutory provisions, that they be given ample time to prepare for alternative accommodation. I hope you've learned something today. Do save this video for later references. Like the video. If there is anything you want to ask, any question at all, any topic you want me to treat subsequently, drop it on the comment section and I will do my best to do justice to it. Don't forget to follow and don't forget to share so that many more people can get the value of these videos. Have a nice day. See you in my next discourse.